Madam Chief Justice, Excellency, the Ambassador to Switzerland, dear colleagues, dear friends. Oh, this is moving by itself. How do you do that? There we go. Many thanks to the organizers for this invitation, and I'm really sorry I missed out on the conference yesterday, so I'll just have to catch up a bit today. I've been asked to present on the subject of child-friendly justice, which I'm happy to do, and the subject took up a couple of my years of life about a decade ago with my friend and fellow member of the UN Committee on the Rights of the Child, Olga Katsova. We spent a few months in Strasbourg as part of the group of experts. That was the beginning, yes. We were drafting the Council of Europe's guidelines on child-friendly justice. This was in 2010. And there was a time when I almost knew the guidelines by heart, forwards and backwards, but no more. So my talk today is a bit of a stroll down a memory lane. And as we all know, memory is inherently malleable. Therefore, what I have prepared for you is a customized child rights conceptual smoothie on child-friendly justice, as well as some experiences as a court-appointed expert in so-called infernal separation and divorce cases, as well as in complex child protection procedures. Let me repeat this: a customized child rights conceptual smoothie on child-friendly justice. And just to be sure, if you don't know what a smoothie is, it is a thick and creamy beverage made from pureed raw fruit, vegetables, and sometimes dairy products, typically using a blender. And my talk will blend together a child's rights smoothie, and some of the ingredients will be concepts such as dignity, participation, best interest, access to justice, procedural autonomy, emotional tort, ethics. And I already know what you're thinking. This is a big smoothie. So what I'll do is it will only be a first installment. You'll have to invite me back. There are many advantages for me being nowadays an occasional designated court-appointed expert in Switzerland. One of them is that I have an intimate look at how a given judicial case plays out. If you take the time and you experience some passion for the work you do, in my view, you have the best seat in the whole procedure. Of course, you must be diligent and very thorough, but unless you botch your job bigly, as Donald Trump would say, you are not responsible for decisions that are ultimately taken, especially if they are bad decisions. Those are the judge's problem. Even better, usually nobody really tells you how you should conduct your evaluation. And to top it off, generally the participants, be they children, parents, or professionals, try to collaborate and volunteer at your request to share with you what matters to each of them in terms of parental responsibility, visitation, guardianship, the other parent's behavior, the other parent's meanness, the horrible judge and social workers, and so on. To put it mildly, outside of criminal procedures, you are privy to the very best and worst human behaviors and cognitions, and to the best and worst professional practices. And here is the ultimate test of the notion of child-friendly justice: that the child who goes through a judicial process should not come out of it worse off than when she or he entered. And here I believe judges have a special responsibility under the notion of child-friendly justice. If they are properly trained, or even if they are not, their responsibility is to protect the child from secondary harm associated with the judicial process. If the judge catches a whiff of a child being maltreated by the process or a professional's actions, he or she must act under the foreseeability rule, call it out, and modify the process. I even think that judges should be held accountable for emotional abuse if a child is maltreated during a proceeding carried out under his or her judicial responsibility. Let me give you an example, granted that goes beyond established child-friendly justice thinking. A few years ago, while sharing a long period in a waiting room before being called in to testify in court in an explosive custody case, the court-appointed evaluator shared with the child therapist, and I was the therapist at that point, that he was very satisfied that he had been able to extract everything he needed from the child regarding his father's negative behavior towards his mother. This was a major surprise for me, given that in therapy, the young boy had demonstrated a passionate wish to remain neutral and expressed caring feelings towards both his parents. Damn, I was curious to discover how the court-appointed expert had obtained the information. So I faked admiration for his professional capacity, and he proudly explained how he had become progressively more menacing until he formulated a stark threat. Should the child not confirm some of the hearsay accounts of the father's attitudes, it would be in his power as a court-appointed evaluator to recommend that the child be placed in foster care until he became more cooperative. Obviously, no reference to this highly questionable method was mentioned in the court report or expressed in court testimony. And he was sharing this with me with pride and as a diligent professional. Luckily, the child himself was subsequently called in to testify in a restricted hearing without his parents' presence, and the astute judge had no trouble noticing a complete disconnect between the child's views and what the court evaluator had reported. However, the full extent of the court evaluator's unethical method never officially surfaced. And here I think that the judge should have reported this expert, which he did not do. He just ignored his findings. So let me put some of the ingredients in this movie. Under the definition of the 2010 Council of Europe guidelines, child-friendly justice means creating a justice system which guarantees the respect and the effective implementation of all children's rights, giving due consideration to the child's level of maturity and understanding and to the circumstances of the case. It is in particular justice that is accessible, age-appropriate, speedy, diligent, adapted to and focused on the needs and the rights of the child, respecting the rights of the child, including the rights to due process, to participate in and to understand the proceedings, to respect for private and family life, and to integrity and dignity. I think Olga and I are quite proud of this definition. And please note that the Council of Europe guidelines apply to all ways in which children are likely to be, for whatever reason and in whatever capacity, brought into contact with all competent bodies and services implementing criminal, civil, or administrative law. But whereas the child-friendly guidelines concern all children, including victims, witnesses, and children implicitly concerned, such as in separation and divorce cases, I must underscore that the guidelines are somewhat tilted towards children in conflict with the law and those caught up in criminal procedures. Let me mention the 2005 United Nations Guidelines on Justice in Matters Involving Child Victims and Witnesses of Crime, which define the notion of child-sensitive, child-friendly, child-sensitive, as an approach that balances the child's right to protection, and that takes into account the child's individual needs and views. And to be even more complete, the International Association of Youth and Family Judges and Magistrates produced the guidelines on child in contact with the justice system, which were developed on the basis of the child-friendly justice guidelines, and these guidelines use the term child-focused justice. These sets of guidelines are emphatically set on child rights, on a child rights foundation, and explicitly refer to the same core principles of which I chose to highlight participation, best interest, protection, and harmonious development. And let us not forget the notion of dignity, which the Council of Europe spells out as follows. Children should be treated with care, sensitivity, fairness, and respect throughout any procedure or case, with special attention for their full situation, well-being, and specific needs, and with full respect for their physical and psychological integrity. This treatment should be given to them in whichever way they have come into contact with judicial or non-judicial proceedings or other interventions, and regardless of their legal status and capacity in any procedure or case. In thinking about child-friendly approaches and how they are meant to transform the justice system, I am reminded of the debate on and the evolution from integration towards inclusion that pertains to the education of children with disabilities. Integration is the adaptation of children who are different to the classrooms as they exist. It is all about assimilation, uniformity, and loss of difference. In other words, children who come into contact with the justice system should adapt to what exists. Inclusion, on the other hand, occurs when the school system adapts to the diversity of its pupils. This is when the justice system bends, changes, and adapts to the full spectrum of its users, including children, and provides them with pathways to access the system, and even more importantly, empowers them to seek authentic and meaningful justice in a way that they are not discriminated against in any fashion. And this is the only way in this to achieve Target 16 of the Sustainable Development Goals, which call for ensuring equal justice, access to justice for all. Now, there is a very long road ahead. The Convention on the Rights of the Child is at its core all about best interest and participation. Article 3 of the CRC is very clear. In all actions concerning children, the best interest of the child shall be a primary consideration. And General Comment 14, which provides the committee's guidance on Article 3, is also clear. Every action relating to a child or children has to take into account their best interest as a primary consideration. The word action does not only include decisions, but also all acts, conduct, proposals, services, procedures, and other measures. And I'm not operating any magic with this demonstration, but for the best interest to be fully and respectfully ascertained and assessed, the child's participation is unavoidable and obligatory, except in the most unusual of circumstances. But here is where children crash into all the barriers that deny access to justice and make child's participation just a slogan. The barriers are numerous and draw from adults' perceptions of children as incapable, procedural barriers of many types, lack of information, and the list is long. Perhaps the most eloquent way to put it is to cite some numbers. In Switzerland, the estimate concerning the number of children expressing their views in some formal manner in the context of parental separation or divorce is somewhere between 10 and 15%. A Danish study on complex divorce proceedings states that about 1/4 of children are involved and given an opportunity to express their views. With situations of children heard in protection procedures, the numbers tend to increase somewhat, but there is scarce data on how these children are heard and to what purpose, and if their opinions are given due weight. Indeed, Article 12, and I'm not going to read the article, it's already been mentioned, does state that the children's participation is paramount and that they should be heard directly and or through a representative or an appropriate body. And here I tend to differ a little bit with what has been said so far. I would like to put to rest a small controversy regarding whether the child should be heard directly or indirectly, and if indirectly is sufficient. In other words, in a divorce case, should a judge hear the child directly, or is it enough to hear the child through a social worker's account or a specialized lawyer? The committee in its comment number 12 on the right of the child to be heard has been rather forceful, recommending that whenever possible, I quote, the child must be given the opportunity to be heard directly in any proceedings. The only reasonable exceptions would be if the child, him or herself, does not wish to be heard directly or indirectly, or if the process of participating and being heard has a detrimental effect on the child. In other words, protection concerns should rightly kick in. In my personal view, directly hearing the child should also take place when it is known beyond doubt that the child is parroting a parental talking point, such as in alienation cases. It provides an opportunity for the judicial authority to introduce a reality check on the child and the manipulative parent's omnipotence. And hearing the child should take place even when parents divorce by mutual consent. In fact, the French ombudsman, defender of rights, as they're called in France, has criticized so-called mutual consent divorces because the child's best interest is not sufficiently assessed because he's not or she's not invited to participate. Let me step back and reset my talk. For those of you seeking a well-thought-out catalog, you should take a look at this publication by the European Union's Agency for Fundamental Rights. You will get great ideas with regard to the necessary structural and process reforms that are needed in your legislation, and also some ideas about outcome indicators. Child-friendly justice is a holistic concept that seeks to ensure that children access and participate meaningfully in all judicial matters and procedures. It is a process over time. It involves numerous professionals, and there are many points at which a child witness, victim, or party can join in the proceedings or be solicited. Therefore, for child-friendly justice to have some meaning, all professionals involved in this complex process must have the awareness, the training, and the mandate to incorporate the necessary steps to ensure that the rights of the child are respected. Let me break this down. I'm always amazed when I survey groups of professionals like yourselves, jurists, health professionals, social workers, how few have read, for example, the Universal Declaration of Human Rights. And the same is true for the Convention on the Rights of the Child, the Guidelines on Child-Friendly Justice, and many of you have not yet read the General Comment 24 of the Committee on the Rights of the Child on children's rights in the justice system. The Guidelines on Child-Friendly Justice call for, and in fact the UN Committee on the Rights for the Child calls ad nauseum for advanced interdisciplinary training on children's rights for all professionals working with and for children. In addition to training, domestic law must incorporate the principles of child-friendly justice by mandating that children be given the opportunity to participate and setting rules that allow this participation. That it be also dignified, respectful, and meaningful. And here I would also like to cite the great pediatrician Janusz Korczak. Quote, "You will never know the children while having contempt for their complaints." For example, Section 14 of the South African Children's Act grants, I quote, "every child the right to initiate judicial proceedings." Doesn't specify an age, by the way. Legal empowerment of children, providing them with procedural autonomy, requires specialized courts, child focal points, and accessible complaint mechanisms, specialized child lawyers who are paid decently, extensive sources of information, including child-friendly online applications, dedicated staff with lots of time and able and willing to inform children of the full extent of their rights. And here you have some really great publications, one by Helen Stalford, who I saw is associated with this conference, on the right to information, which is a huge avenue into child-friendly justice. There are also some excellent contributions by my friend Ton Liefard and his team at Leiden University. But outside the field of law, and rarely cited by jurists, here it is, interdisciplinarity. Child development psychologists have studied how children understand legal concepts and what strategies help them navigate the system. A good starting point is a pioneering article by Karen Sawitz with the delightful title, "Children's Conception of the Legal System, Court is a Place to Play Basketball." And there needs to be much more research on children's participation in the justice system and the degree of friendliness that characterizes their involvement. I've been asked to go a little bit faster, which I will, so I'll skip a bit. So before I conclude, let me remark that I feel I've been all over the place. So let me ground you with a personal belief. Wherever we sit and operate in the wider justice system, at the edge looking in, or in the midst coping with its complexity, I strongly believe that as professionals, we not only have a duty to comply with moral expectations and ethical guidelines, but we also have a duty within our practice to contribute to a society of professionals that are caring and practicing in line with fundamental human rights without any discrimination and prejudice. And this can take many forms, and each and all of us will recognize for ourselves what this refers to. As far as I'm concerned, one of my deliberate contributions is to cite the Convention on the Rights of the Child and other guiding human rights documents in my reports to the courts. I also flag best practices and reprehensible behavior of professionals in the reports I write, always in a respectful manner. One example, in reviewing a file of a young girl victim of child sexual abuse, I was struck by the incredibly high quality of the specialized interview by the policeman. He was so respectful, so attentive to the child's needs and capacity, that it was not that important in the end that the young girl did not provide as much as she may have if the interviewer had been more forceful. And I could give more examples, but here again, I'll just skip them for the sake of your mental health. Let me conclude by adopting and transforming an argument that my colleague Ton Liefard makes. We have plenty of standard setting documents, and we are moving towards implementing access to justice for children in a piecemeal national and regional manner. So be it. But the justice system needs to be held accountable for how it respects children's rights. And here the optional protocol to the Convention on the Rights of the Child on a communications procedure, OPIC, points in the right direction. If there is no access, 2 sentences, if there is no access, no meaningful participation, and other rights violations, individual complaints should be formulated and met with remedies and even significant compensation. We need to put some teeth in the rights of the child to access justice and be treated in a child-friendly, child-sensitive, and child-focused manner. But I really do wish that children could express themselves with greater clarity, because it's not always so evident. Thank you very much.